Good morning.
Good morning. May it please the court, Karen Shimonsky on behalf of appellant Bove Grand, DBA West Shore Pizza Village Center. I'd like to reserve 3 minutes for rebuttal, please. This is an appeal of a final order that was improperly substantively changed after the lower court had no jurisdiction to do so. The underlying final judgment in this matter was entered on March 24th in favor of appellee. After the judgment was entered, appellee filed a motion for attorney's fees and costs pursuant to a PFS. That PFS was ultimately determined to be ambiguous and unenforceable. At the hearing on the enforceability of the PFS, appellee also raised an argument that they were entitled to prevailing party costs under 57.041, and the order was then subsequently entered on April 6th, 2017. The hearing took place in September 2016. So on April 6th, 2017, when the order was entered on the motion for entitlement to fees pursuant to the PFS, the order read, "The motion for entitlement to attorney's fees and to tax costs is denied." That same day, and actually before that order was docketed, that same day an amended final judgment was entered. Also, that final judgment did not include entitlement to prevailing party costs.
Putting aside the title of the motion, remind me, it is the case that the focus on the hearing was on the question of the attorney's fees.
The focus of the original hearing was on the enforceability of the proposal for settlement. Okay. Yes.
So the costs sort of stayed off on the sidelines.
Well, while they raised that they were entitled to prevailing party costs, yes, the focus was on the proposal for settlement. However, the motion that was written by appellee and the actual wording of the final order was motion to tax fees and costs is hereby denied.
So your position is that was a deliberate judicial action to deny costs, as opposed to just putting in the title of the motion and thinking, oh, we were only talking about attorney's fees at the hearing.
My position is that I think it was error that the judge denied prevailing.
They were absolutely entitled to costs.
They were entitled to costs. It was error that the judge denied prevailing party costs. However, the type of error that it was needed to be remedied by a motion for rehearing pursuant to 1.530. If you look at the case law that discusses the difference between 1.540B and 1.30, even when the judge makes an error, even if it's not an intentional mistake, for example, if you look at the case of the estate of Beeman, I think that this case is very close on point here. In the estate of Beeman, which is 391 Southern 2nd 276, it's a 4 TCA case. This court also relied on that in the Palladian Properties case, which was a 2007 case in this court. There, the judge mistakenly awarded attorney's fees to a party, forgetting that the cause of action under which they were entitled to attorney's fees, a contract clause, had been waived and was disposed of at the time that the judge then awarded attorney's fees. It was a mistake. It was an error. However, the fact that the court forgot the entitlement to attorney's fees provision was no longer there did not.
But even in that situation, though, the judge consciously ruled to award the fees. You know, in doing so, the judge had forgotten something that might have caused the judge to rule differently. But here, as I understand, Judge Foster said he didn't really mean to deny costs.
Correct. He did not mean to deny prevailing party costs. However, that was before him when it was raised before him, and he entered an order denying it, and it could have been remedied. But we have the rules in place for a reason. Plaintiff could have filed within the 15-day time period a motion for rehearing. Plaintiff deliberately chose not to, and plaintiff, when they filed their motion for reconsideration, which they called it, it was at day 27. They could have filed a notice of appeal at that point. And they said at the hearing on the motion for reconsideration, they deliberately chose not to file a notice of appeal because they didn't want to wait 18 months to go through the appellate process to have this remedied the way that the rules provide we must do it. If the rules set forth that there is a mechanism for which you have to correct it, at day 16, the lower court lost jurisdiction to make a substantive change to that order. And this is certainly a substantive change to the order because it went from denying $30,000 in costs to ultimately awarding $30,000 in costs. So the fact that this was an error doesn't mean that the court is permitted to just change this under any mechanism plaintiff chooses, but rather plaintiff must follow these rules and must either, they had multiple options, file it within 15 days within the lower court or file a notice of appeal with this court. They deliberately chose not to do either.
1.540, I'm sort of trying to figure out where this case falls. I mean, clearly a transposition error would be correctable.
Yes, Your Honor, and I think that's exactly what it is utilized for.
Okay.
Just because Judge Foster said he inadvertently denied cost doesn't mean that it falls within inadvertence under 1.540. If you sign the wrong order, let's say, or the wrong date on the order, let's say, certainly that's the type of non-substantive order, or non-substantive change to the order. And the case law not only says that a mistake of fact, but also a mistaken view of the law is not a circumstance that's contemplated within the rule.
Right, but didn't he say, look, I didn't mean to deny costs. Signing an order to deny costs was an inadvertent mistake. As opposed to, like you point out in Beeman, where it says, yeah, I ruled to award attorney's fees, but when I did so, I forgot some fact that would have made me rule differently. Those are two very different things, are they not?
Respectfully, Your Honor, I don't think they're very different because just as Judge Foster forgot that there is a prevailing party provision that would award them costs, I mean, his order stated they were not entitled to fees or costs at all. He forgot that there was another provision under which they were entitled to costs in this circumstance. In the same Beeman, that judge forgot that that the mechanism by which they were allowed to recover fees was not at issue, was not in play anymore. So just as in Beeman they forgot that fees weren't permitted, Judge Foster forgot that prevailing costs were permitted under a different mechanism other than the PFS. And I think that the primary focus here should be the effect that the change has on the order. Because I think the case law, if you review the case law, you'll see that a substantive change to the order is a 1.530. The Florida Supreme Court in the case of Corbello versus Ullman, in that case, one party, the lower court thought a party waived their right to jury trial and proceeded with a bench trial. Ultimately, it was determined that was a mistake. They had not waived their right to a bench trial. The lower court was incorrect in thinking that, and that should have been remedied. However, the Supreme Court said a mistaken view of the law is not one of the circumstances contemplated by the rule. That if an error substantively changes the order, that's a 1.530. And I think if we focus on the policy considerations here, during the motion for reconsideration hearing, plaintiff's counsel, both in written argument and orally, also requested reconsideration of the denial of the PFS. So they were also asking the court, they did not just go back and say, everyone forgot about this, about the prevailing party fees, order that. They said, also, I think you should reconsider the denial of the PFS.
The court didn't grant that.
They didn't grant that,
So
but if we allow them to open the door.
He treated those differently, didn't he?
Well, yes, Your Honor, but my point is if we allow the court to open the door here and say after day 15 you can make substantive changes, why wouldn't the court be allowed to make a substantive change to that PFS at day 27 as well?
Well, because he intentionally denied fees, but he didn't intentionally deny costs, according to the judge. The denial
Correct.
of costs was an inadvertent mistake.
An inadvertent mistake, it was he forgot that there was an entitlement to fees under prevailing party costs, and that should have been remedied through a motion for rehearing or a notice of appeal. Just as this court wouldn't have jurisdiction if I filed a notice of appeal at day 31, neither did that court have jurisdiction to make a substantive change to the order. Just as important as it is to allow the court to make changes pursuant to the two of the rules, so is it to preserve the finality of judgments here. And I think, again, plaintiffs showed their true intentions. They didn't want to use the rules as prescribed. They didn't want to wait 18 months, according to them, to have to go through the proper channels of pursuing it via an appeal. And I think opening the door and not enforcing the rules here is a very slippery slope that if a substantive change to the order must stay under a motion for rehearing 1.530 timeframe. If Your Honors are inclined to find that this was okay to remedy via 1.540, then we do ask that the amount of costs awarded be remanded and revisited with the lower court. The total amount awarded was about $30,000. However, plaintiff did not present detailed evidence as to that all of the costs were reasonably incurred or that they were recoverable costs. This is cited in the record. I asked the court will look at it. It's pages 313 to 326. There's a broken down chart that lists all of the costs that were requested, all of the objections thereto, the amount that we requested be awarded. Just as a big overview, things such as expert costs, for example. Plaintiff was allowed to recover all of the amount they asked for expert costs, and some of them they presented just a check that was paid. There was no breakdown that was showing that it was in a line with the uniform guidelines as to which costs are recoverable. Specifically, just to kind of give examples, because these are big numbers here. One of the experts was awarded $4,000 just by producing a copy of a check that was paid to her. There was no detailed description of what she did. This was Dr. Maxey. And to our knowledge, all we know is that she testified for 1.5 hours at trial. Certainly, that is not a reasonable fee for an hour and a half of testimony. Maybe she did preparation work. Perhaps she was charging for travel that the uniform guidelines do not prescribe. We don't know. The bigger point here was that Judge Foster permitted recovery of almost all of the fees, or all of the costs that were requested. I think he deducted about $200 without a detailed showing that these costs were reasonably incurred and necessary to prosecute the case, or even that they were within the guidelines of recoverable costs. Multiple copies of depositions were allowed to be awarded and recovered when the rules clearly state it's an original and a copy. One of the other experts just produced an invoice which showed the hourly rate fluctuated dramatically between deposition testimony and prep work without an explanation as to why. So we were just asking that this be remanded and the plaintiff be required to delineate specifically, as most judges require, as to that these costs were reasonably incurred and that they were reasonable amounts of reasonable fees that were charged. So we, of course, first asked the court reverse lower court's ruling and awarding prevailing party costs and reinstate the original order denying it, or subsequently remand, please, for a revisit of the actual costs awarded.
Thank you, Ms. Szymanski.
Good morning. May it please the court. My name is Brent Steinberg from the law firm of Suo Perdante, and we're here on behalf of the appellee, Angeline Diamond, who is the plaintiff in the court below. Your Honors, this court should affirm the final judgment on taxable costs for two reasons. Number one, Rule 1.540B authorized the trial court to do what it did and to correct its initial inadvertent denial of plaintiff's prevailing party costs. Number two, the trial court didn't abuse its discretion in awarding any of the taxable costs that were ultimately awarded, which came to about $30,000. So if I could first address the jurisdictional question and explain to you why the trial court was authorized to do what it did under Rule 1.540B. I think I need to back up and go over this procedural history because from the defendant's description of what occurred, it's a bit misleading. So if you could just bear with me for a couple minutes, I think it'll make it all clear. So as you heard, we filed a motion for attorney's fees and costs, and there were two bases for that motion. The first one, we were seeking fees on a proposal for settlement that we alleged we triggered, and the second, we sought taxable costs as a prevailing party under 57041. The defendant disputed entitlement to fees under the proposal for settlement. They said it was impermissibly ambiguous and therefore moved to strike it. But at no point did they ever contest that we were entitled to prevailing party costs, nor could they. The hearing goes forward on the motion, and it focused on the validity, only focused on the validity of the proposal for settlement. And at the very beginning of that hearing, it was agreed that the issue on the amount of the taxable costs would be put off for another day. So at the end of that hearing, the court reserves ruling It asked for additional briefing on this proposal for settlement issue, and then 6 months go by. At the end of that 6 months, on April 6, 2017, the court denies our motion and strikes the proposal for settlement. Now, in response to that order, we actually filed 2 separate motions, and this is the point that I think got glossed over, but there were 2 separate motions that were filed. First, we moved for reconsideration, and the court denied that motion, finding that it was untimely under Rule 1.530. And I won't get into the details of it, but there was a dispute initially about whether it was a final order or not final order. The court determined it was a final order, therefore untimely. But regardless, we haven't appealed anything about the proposal for settlement. We haven't appealed anything about the denial of the motion for reconsideration. That issue is done and over with. What this appeal about is the second motion that we filed, which is the one that the court granted. And that was the motion for relief from the order that denied our taxable costs that we filed specifically pursuant to Rule 1.540 subsection B. That's the motion that the court granted. The judge exercised his discretion to find that he was able to fix his own inadvertent denial of the costs. The order that denied the motion for costs and fees just said denied. It was a blanket denial. It was supposed to say denied as to the proposal for settlement, but it just said denied. And the judge admitted repeatedly that this was an inadvertent mistake. He said it was unintentional, and he characterized it as a scrivener's error. Well, Rule 1.540B exists for this very reason. It allows the trial court to amend a final judgment or order to fix its own mistake. A motion made under Rule 1.540B just has to be done within a reasonable time period and not later than not later than a year after the entry of the mistaken order. And our motion was filed 39 days after the mistaken order, and it explicitly said that it was being made pursuant to Rule 1.540B. Now, both parties have cited cases explaining that courts are able to fix their own honest and inadvertent mistakes that were made during the course of litigation under Rule 1.540B. To determine whether a mistake is honest and inadvertent, the courts have looked to, and Judge Northcutt, I think you touched on this right on the head, but the courts look to whether or not the trial judge intended to enter the order as drafted. That's the key. If the trial court did not intend to enter the order as drafted, Rule 1.540B applies. And that's exactly what happened here. The judge explained that he meant to deny plaintiff entitlement to fees under the proposal for settlement, but at no point did he intend to enter an order saying that it was denied as to taxable costs.
The first time around, if the judge had entered an order that says, I deny, well, if the judge believes that he cannot award cost and he denies the motion, that would have to be within the 15-day period.
If the judge had said, I find that the plaintiffs were not a prevailing party, or he said, I find that 57041 doesn't entitle the plaintiff to taxable costs, something like that, I would agree with you that that would be what the courts characterize as a judicial error. That would be a deliberate choice that the judge made, and that would either have to be appealed or a motion for rehearing would have to be filed. But there's no evidence that that's what happened here, and in fact, the evidence is the exact opposite.
Well, and in fact, the order did not say plaintiff is not entitled to costs. The order said plaintiff's motion for entitlement to attorney's fees and to tax costs, which was the title of the plaintiff's motion, is denied. Correct?
That's correct, Your Honor. And I'm looking at page 254 of the record.
I wasn't intending to deny costs. I was intending to deny, because there was a motion in that same order, there was a grants the defendant's motion to strike the proposal for settlement.
Precisely. So, as to the defendant's judicial error argument, there's nothing in the record to support the contention that the judge had made a deliberate choice. The record is the opposite. He wasn't confused about the law. He didn't forget that we were a prevailing party. He just made a simple, honest mistake when he entered the blanket denial of costs, and instead of just limiting it to the proposal for settlement issue, which, according to the judge, is what he intended.
Well, the construction that's being suggested by your friend is to wholly render 1.40 superfluous. I mean, I can't And that's going to be my question on rebuttal, is what's the point of 1.540 if you only have 15 days? That's to go toward a rehearing issue. And after that, it's to go through, well, let's just make sure there aren't under subsection A any clerical errors which happen. And then B, it just kind of caps it out as 1 year as to a mistake. I think there would be a stronger argument for your friend had the court reasoned out in the order rather than just saying denied why it was denying it. It sounds to me like this was just a summary order that was just entered without reasoning, and when the motion pursuant to the operative rule here, which I think is 1.540, came in, it provided the court an opportunity to make a finding that, oops, this is a mistake, I inadvertently entered this, I didn't mean to enter this, and et cetera. Would you agree then that the construction as it's being asked us to look at 1.540 the rule wouldn't even exist if we were to accept the construction?
I do agree, Your Honor, and not only is the defendant's argument that 1.530 would render 1.540 superfluous with the timing, they're actually asking you to render 1.540B superfluous by looking only into 1.540A. So 1.540A deals with clerical mistakes, and there is case law in the clerical mistakes context talking about how the order or the amended order can't substantially change the impact and effect of the order, because if it does, it's not a clerical mistake.
Yeah, I think the rule's there just simply to prevent the exact kind of windfall due to an omission, mistake, inadvertence, things of the trial court. It's for this very purpose in my view of the construction of it.
I agree, Your Honor. So under Rule 1.540B, it was entirely appropriate for the court to do what he did. And as to their argument that we were somehow precluded from filing a subsequent 1.540 motion because we'd previously filed a motion for reconsideration, there's nothing, no authority supporting that. And in fact, if you look at Rule 1.530 subsection G, it specifically says this rule does not affect the remedies in Rule 1.540B. So clearly, under Rule 1.540B, the court had the authority to do what it did. There was no 15-day time limitation. So if I could just move on to the second issue, I feel like we've addressed the jurisdictional question unless the court has additional questions on that. And let me briefly discuss why the trial court did not abuse its discretion in awarding the $30,000 of costs. First, I would ask the court to keep in perspective what its function is here. Respectfully, it is not your job to go through the invoices line by line and try to figure out if every single cost was reasonably necessary at the time that it was incurred. The trial court did that. Your job is just to review for an abuse of discretion. We had an hour-long hearing where all of the costs were discussed in detail, and the court made its determinations about what was and was not reasonably necessary. And although the defendant certainly takes issue with some of the charges, it never explains how any of the awards were in abuse of discretion. So on that basis alone, this court should affirm. If you do want to look at the specific charges, they're complaining about 4 general categories. I'm going to briefly touch all of them. In the argument, the first thing that was referenced was expert charges. There was and it's not that we're not entitled to recover expert charges. The defense is just saying that the award was $5,450 too high. This argument fails for 2 reasons. Number one, they waived it. The court offered to have a day-long evidentiary hearing where we'd bring in all the testimonial experts to come in and they could be cross-examined about the reasonableness and the necessity of the charges. And defense rejected that offer. They said that they wanted to have a ruling that day without any additional time or cost. So having declined the opportunity to challenge the reasonableness and the necessity of the costs at the trial level, they shouldn't be heard to complain about it here. The second reason why that argument fails is that they're relying upon cases which are no longer good law. There's case law from before 2005 which says that under the uniform guidelines, charges made by experts for preparing expert reports or having attorney conferences are not recoverable. But then in 2005, the Uniform Guidelines are amended, and the language from the Uniform Guidelines upon which those cases was relying was removed. Since 2005, the appellate courts have held that trial courts have broad discretion to award any expert charges for time preparing for deposition or for trial, and that would include the attorney conferences or the other issue that they're complaining about was the preparation of the report. So clearly the trial court had the discretion to determine that the charges were reasonable, and the defense hasn't shown any abuse of discretion. The second category that they were complaining about was additional court reporter charges above the cost of the deposition transcript itself. That included conference room rental fee, shipping and handling charges for the shipping of the original transcript. I believe there was one for the cost of the CD. The defense said that we can't recover those because they're overhead. Well, they aren't overhead, and these are charges that we incurred specifically for the purposes of this case. They were charges that we had to pay to a third party in order to procure the court reporter services and a copy of the transcript. So respectfully, it's not overhead, and there was no abuse of discretion. The third argument or category that they complained about was we obtained the deposition transcripts of 3 defense experts. The defense's position is that we didn't need the deposition transcripts because those experts testified live at trial, the defense experts. It should be obvious that we needed the deposition transcripts because they were testifying live at trial. And the whole purpose of deposing opposing parties' experts is to determine what their expert opinions are in advance of trial, and then to have that transcript available to impeach as the case may be. So clearly the court properly held that those were reasonably necessary. The last one is an invoice. It was about $1,400, and it was for trial exhibit and demonstrative aid printing charges. The defense gave us a CD of all their trial exhibits. They were voluminous, so we had to have them printed, and at 15 cents a page, that came out to over $1,000. There's a case directly on point, which both parties cite, called Landmark Winter Park versus Coleman. It's a 50 CA case from 2009 that says the cost of photocopies of trial exhibits is taxable under the Uniform Guidelines, so the court properly held they were taxable. Now, as to the rest of this $1,400 invoice, I need to correct something that I said in the answer brief. We initially said that those were all for the trial exhibit printing charges, but after reading the reply, I went back and I looked at the invoice in a little closer detail, and I missed initially that $260 of that $1,400 invoice does appear to have been related to demonstrative aids, the printing of them. So I apologize to the court and counsel for misstating that in the answer brief, because clearly $260 was for demonstrative aids. Regardless, there's no dispute that charges for demonstrative aids are recoverable so long as they're reasonable and useful to the jury. And here the trial court determined that they were reasonable and would be useful, so there's no abuse of discretion. So to sum it all up, the defendant hasn't met its lofty burden of demonstrating an abuse of discretion in awarding any of the costs, and the trial court clearly had authority under Rule 1.540B to correct its mistaken order of April 6, 2017. And on that basis, the plaintiff and the appellee would respectfully request that you affirm. And if there aren't any additional questions.
Thank you, Mr. Steinberg.
All right, thank you.
Ms. Szymanski?
Just briefly, Your Honors. To answer the first question that was posed by Judge Badalamenti as to why my argument as to what 1.540B should be used doesn't render the rule superfluous, because as I read the rule and as I interpret the case law reading the rule, B has to do with a
Which B?
1.540B. I'm sorry, Your Honor, is a change to the order that does not substantively impact the effect of the order. Or there's also within that rule in some of the case law that has to do with a fraud or a mistake or inadvertence, a mistake of fact that was procured by fraud that comes out later. There are purposes of that rule allowing a judge to make amendments to or changes to an order that are because of their mistake or inadvertence, but the case law, I think, interpreting the rule clearly states that if that mistake or inadvertence has a if changing that mistake or inadvertence has a substantive impact on the rule, a substantive impact on the order, then that is a 1.530 or an appeal. It's not a substitute, 1.540B is not a substitute for filing a notice of appeal if you need to make a substantive amendment to an order. That was...
What's your best case?
I do believe it's the estate of Beeman and this court's interpreting or relying on estate of Beeman in the Pladen Properties case, both where the judge was forgetting there was some fact out there that entitled or did not entitle the party to something, and mistakenly made a decision forgetting that was out there. Just like Judge Foster forgot there was an opportunity for them to recover costs under the prevailing party statute. Moving on just briefly to the specific costs, the judge did abuse his discretion here by not requiring plaintiff to meet their burden. It is plaintiff's burden to show that the costs were reasonably necessary and that they conform with the uniform guidelines. Briefly, just on the expert topic, the guideline says the court should tax a reasonable fee for deposition or trial testimony, or deposition and or trial testimony, and expenses only when traveling over 100 miles. Something is allowing plaintiff to recover for just producing a check for $4,000, and all we know, all anybody knows, all the court knew at the time of the hearing, all we knew at the time of the hearing was that that expert testified for 1.5 hours at trial. Allowing a $4,000 recovery for such time is clearly unreasonable, and all we're saying is the court did abuse their discretion by not requiring a detailed invoice as to what was charged. Was there travel time in there with that expert's located in Tampa? If there was travel time in...
Didn't you waive that? You had the opportunity to have an evidentiary hearing where all this could be brought out, but, for whatever strategic reason, Judge, go ahead and do it. We want this done with.
Well, we didn't waive it, though. What we raised at the hearing was there is not a breakdown. We can't attack this charge specifically because we have nothing to attack it with. There were nothing was specifically delineated as to what these charges were incurred for, and that was the crux of our problem. Our crux of our problem was we can't tell if these were reasonably incurred. We can't tell what was incurred. We can't tell if this fee is a reasonable expert fee because we don't know how many hours were spent by this expert for which she charged you $4,000. And that's just one example. All of those arguments were raised at the hearing that we needed to have a more, it's plaintiff's burden, and plaintiff needed to produce a more detailed explanation of the fees and argument as to why they're reasonably incurred before they can be awarded. And refusing to do so is an abuse of discretion, or refusing to require a plaintiff to do that and just blanket award them is an abuse of discretion. So we do ask at the very least, if your honors are not inclined to vacate the award, that we ask that it be remanded for an additional hearing on the amount of costs. Thank you.
Thank you very much. Thank you both.